from the minutes. Item number 1.
What is this about?
My lord, this matter pertains to a tender process, my lord. The petitioner herein, my lord, is a non-governmental organization, my lord.
Why is it a PIL?
My lord,
You participated in the tender.
no, my lord, I am an NGO, my lord.
So, busybody.
My lord, I am keeping watch on over the large procurements in this education sector, my lord.
Sorry?
I am keeping watch on all the large procurements, my lord.
Yes, but who has appointed you to keep watch?
My lord, the huge public money has been involved, my lord. In
Maybe. But you are not affected.
My lord, being a taxpayer, my lord,
No. It's a contractor. Tell us what is it about?
my lord, tender was floated, my lord, for
what purpose?
for installing AI lab and coding, my lord, in the schools of state of Meghalaya, my lord, around
For what?
AI lab, my lord, artificial intelligence lab and coding, my lord.
And coding.
Coding in the schools, my lord, in the state of Meghalaya.
Yes.
There is some specification in the tender, my lord, which only allows only some specific company to participate, my lord. It has one installation kit has been mentioned, my lord, which is only from specifically it is mentioned only from specific company, that is ThinkSpeak IoT, my lord. And in view of that, my lord, the companies from the open sources, my lord, they could not participate.
So there is a one product thing. For instance, government chooses iPads have to be used.
My lord. My lord,
Only one company makes iPads?
No, my lord, that not only one company make the iPads, my lord.
Only one company makes iPads.
My lord.
Other companies don't make iPads.
I'm sorry, my lord. iPads only one company makes, my lord. But my lord, those kits are available with other companies also, my lord. But there is at a reasonable rate, my lord. That has not been given any. My lord.
If it's a single thing, there are certain checks and balances which have to be maintained. Have they not, Mr. Khan?
Yes, Lordship, we have. In fact, actually, the work has been. There are two things, Lordship. So, first of all, Lordship, the petitioner, he is not disclosed exactly what is his locus. And
no, that locus is not in PIL. Locus is not necessary.
Neither, Lordship, that he has disclosed that he is one of the prospective bidder, and because of being a prospective
bidder,
then it doesn't become a PIL. Then it becomes a straightaway. Now,
he specifically says
if you specify something.
No, there's nothing else.
No. We also have to do that while ordering computers and things like that.
Okay.
If we specify anything which is of a particular make, then there are many more checks and balances that have to be put. We can't, then it's not a tender process.
Lordship is correct. In this case, Lordship, all check and balance was taken care of. Work was awarded.
What checks and balances? Everything over here is irregular. It's loot going on. Everything is irregular. No health, no education, no roads, no infrastructure. What's the government doing over here? Making money this way? Yes, tell us.
my lord, that is at page number 43, my lord. The specification is mentioned, my lord. Serial number 5, my lord. At serial number 5, my lord. DI add-on kit, IoT kit, Internet of Things kit, my lord. Here
what is this?
This is, my lord.
IoT kit means?
This is an activity kit inside the AI lab, my lord.
Is this specific?
Yes, my lord. At the last line, my lord. ThinkSpeak IoT housing monitoring, my lord. And ThinkSpeak is a specific company, my lord. It's not from an open thing, my lord. And the license fee of this company is very high, my lord. It's a company from outside, my lord. The license fee is very high. And my lord, one more thing, my lord. The L2 and L3, they don't have the license of this startup Indian DIPT license also they don't have, but they have been qualified the pre-bidding pre-qualification stage, my lord. They have crossed.
L2 and L3 do not have, where is that eligibility criterion?
It's at 27, my lord, page 27, my lord.
You must have been set up by some other...
My lord, they are the proxy, as far my information, my lord, they are the proxy companies of L1, my lord.
L2 and L3, page 27.
My lord, the page 27 is my lord, the criteria is at serial number 9, my lord.
Yes.
So any startup of education sector registered under startup...
Where are you? Which clause?
My lord, clause 9, my lord.
Yes.
They don't fulfill this criteria, my lord. But they have been qualified. They have
Very well.
qualified
Though it appears that the petitioner in this so-called public interest litigation may have been set up by some interested agencies in filing this petition, several irregularities in a tender process pertaining to supply, installation and maintenance of coding and AI lab for elementary and secondary schools have been brought to the notice of the court. Paragraph. The petitioner claims that in the list of lab equipment appearing as Annexure 1 appended to the request for proposal, item number 5 pertaining to DIY add-on kit refers to Think, Speak, IoT,
house monitoring.
Which is a licensed product, a specific organization, full stop. In essence, the petitioner complains that persons who have not obtained license of Think, Speak, IoT house monitoring would not be able to participate in the process or offer the software. Paragraph. In addition, the petitioner claims that the second and third lowest bidders have been found eligible and have been shortlisted for consideration, though such L2 and L3 fail the eligibility criteria set out in clause 9 set out in clause 6(9) of the
Request for proposal.
RFQ terms and conditions setting down the general eligibility criteria. Full stop. Paragraph. The petitioner also apprehends that L2 and L3 may be associates or name lenders to ensure name lenders associates of L1 or proxy bidders who have been set up by L1 to ensure that there are at least 3 eligible tenderers for the process to go through. Full stop. Paragraph. Ordinarily, comma, a grievance of the present kind pertaining to acquisition of material by the state may not have been looked into. Full stop. However, comma, considering the nature of the allegations and the abysmal state of governance in Meghalaya, with no proper healthcare, education, or infrastructure, comma, it is necessary to look into such matter. Full stop. Paragraph. The state will respond with a preliminary report from the secretary in the State Education Department to allay the misgivings that the petitioner harbors and has brought to the notice of the court. Full stop. The matter will appear a weekends. Any further steps taken pursuant to the RFQ will abide by the result of this petition.
Last minute.
Lordship, I just need to mention 2 things, Lordship. As per the NIQ, Lordship, the work order was issued on 29th March 2023.
On 29th?
March.
March 2023.
Then?
And pursuant to the work order, the supply has been completed. And only thing, the ongoing training with the teachers are in process.
Then?
It's a case of fait
Should have
accompli.
told us right in the beginning, Mr. Khan.
Lordship, I was about to, when Lordship had expressed, I was about to make that submission in Lordship, and some other aspect.
We have kept.
Though the petitioner brings certain anomalies to the notice of the court pertaining to a request for proposal floated by the state for supply of AI and lab equipment to primary and secondary educational institutions in the state, it appears that the work order in such regard was issued on
29 March 2020.
March 29, 2023. Full stop. The state also submits that substantial supplies have been effected. Full stop.
Completed, Lordship, supply has been completed.
And in several
ongoing-
cases,
ongoing training.
the supplies have been completed. Paragraph.
Ongoing teacher training is in process.
The state will take note of, in such view of the matter, this petition cannot be taken any further. Full stop. However, the state will take note of the anomalies pointed out, particularly since one of the complaints is that the RFQ was designed to obtain a single product or a product exclusively manufactured by a particular firm or organization, and that bidders not eligible in terms of the eligibility criteria were shortlisted for consideration only to ensure that the formality of showing 3 qualified bidders could be gone through for L1 to be awarded the contract. Full stop. Paragraph PIL number 6 of 2023 is disposed of without any orders to cause. If any mistake has been made by the state, the same should not be repeated, and corrective measures should immediately be taken by the Education Department. Yes.
Item number 2.
Need please, Your Lordship.
Yes.
Lordship has taken a view, prima facie view, my lord, that in view of Article 173, my lord, the state is denuded of Article 173. Your Lordship has state is denuded of its power to add or add qualification or disqualification, my lord. 173.
One
173, my lord. 173.
Yes.
A person shall not be qualified to be chosen to fill
Yes, in that. Now, just show us where we can find the original clause
that at page 48, my lord. That is.
of the fact thing, na?
Yes, my lord.
Do we have a lesser?
46 is the original. 6 and 7. 40 page 46, my lord.
46.
Yes.
46 of what?
Of the writ petition, of the appeal, writ appeal, my lord.
No. 46 is something else.
It's part of the paper book of writ appeal, my lord.
It's where we'll find the judgment also.
Yes, my lord. The judgment is separate compilation, my lord. There are 2 compilations of the judgment, my lord.
No. Yes, writ appeal we're looking at page 46 is
It starts from, my lord, page 42.
40 rules regarding conduct.
Yes, regarding conduct and discipline of employees aided.
Oh. And we are looking at number 6.
Number 6 at page 46, my lord.
Sorry. You're right.
No employee shall offer himself as a candidate for election to a legislative body or for holding office of any political organization, except in accordance with provisions of Rule 7, provided that an employee may seek election as an independent candidate of a panchayat, the previous approval of the managing committee, as the case may be, but he shall not be entitled to accept any office thereunder except in accordance with provision of Rule 7. 7. And in any employee desiring to seek election to legislative body or to hold office of any political organization or local body shall be on compulsory leave without pay from the date of filing his nomination till the announcement of result by the proper authority, and shall be eligible to rejoin his post immediately in case he is elected. In case he is elected, he shall be on compulsory leave without pay from the date of filing his nomination till the termination of his office to which he is elected. Such elected employee shall be allowed to retain a lien on his post for a period not exceeding the full term of the elected body to which employee is so elected. In the event of such employee joining the post again, which he had a lien, the interim period of absence on compulsory leave will count for notional increment benefit of pay from the date of such rejoining, my lord. And the amendment is at page 87, my
So
lord.
this is the old one.
Yes, this is the old one, and the amendment is page 87, my lord, which is under challenge. Which is the notification dated 23rd March 2021. 87.
So then it becomes,
Yes, sir.
no employee shall, for any political organization, full
Yes.
stop. Political organization, full stop.
Up to this, full stop. No.
7 goes, proviso to 6 gone.
Yes, sir.
Yes.
As
And your justification, what is your justification?
justification is, my lord, that first that I have the authority to regulate the service conduct of the aided educational institution. Second,
Government has authority.
to regulate the conduct of employees of aided educational institution, my lord.
Conduct of aided educational institutions. And the authority for that is?
The authority for that is, my lord, that grant is being,
No. What is the judgment that you had cited?
the judgment we are citing on this, my lord, is the state of Assam versus Ajit Kumar Sharma, 1965, 1 SCR 890, which is
65 SC 1196.
yes, that is TMA Pi, my lord. TMA Pi.
TMA pi cannot be 65.
Sorry. State of Assam versus Ajit Kumar, 1965. Yes, my lord.
1965 SC
Yes, my lord.
1196. AIR 1965 SC 1196.
It's part of the compilation, my lord. That is.
We'll look at it.
At page 69 of the compilation. my lord.
Page 69.
Yes, Lord. There are two compilations, my lord. One starts from Anup Banwal and the other starts from N. Punnuswamy.
The other starts from?
N. Punnuswamy, N.P. Punnuswamy. The spiral one. Yes, ma'am.
The second one does not have any cover page.
Yes, it is without cover page.
Yes,
And relevant paragraphs, my lord.
11 to 13.
Yes, 11 to 13, my lord. And paragraph 12 at page 74, my lord. And this judgment has been followed, my lord.
Just a second. And what was that, what was offending in the clause?
In the compulsory leave joining, your lordship will see that clause is quoted at page 70, my lord.
Yes.
And there the page 70, the person has to join after the academic year.
Where?
That lordship will see that at page paragraph 3, middle of the page, my lord.
Yes.
The director informed the college after 10 line, my lord, of page 70 in paragraph 3, informed that he is unable to approve the resolution of the governing body permitting the respondent and certain other teachers to rejoin their duties immediately. The latter pointed out that such permission was in contravention of Rule 7 of Rules regarding the conduct and discipline of the employees' rule of aided educational institution and could not therefore approve.
So this was also election.
Yes, my lord.
He was defeated, thereafter applied.
Yes. Because your lordship has seen the rule. The rule is identical, unamended rule is identical. Rule 7 says that he can join immediately.
An amended rule is not identical. The rule underwent amendment.
Yes, he is eligible to rejoin his post immediately.
Yes, immediately.
Yes. And that rule is also quoted at page 72, my lord.
Any employee desiring to seek without pay from filing or nomination by proper and shall be eligible to join immediately in case he is compulsory from date of So the rule says immediately.
Yes, Your Lordship. 72, but the unamended rule is slightly different at page 47, you know, of slightly, the purport and the
Purport, no, we don't know what this.
Your Lordship will see rule 47 and side by side page 72. Your Lordship may have both
Rule?
page 47 of the writ appeal, my Lord,
Yes.
and 72 of the judgment compilation, my Lord.
72 of the?
Judgment compilation where rule is quoted, rule 7 is quoted, my Lord, of the Supreme State of
Any
Assam.
employee shall be on compulsory without pay from data till the end of. Oh, the rule was different. You made it immediately thereafter.
Yes, yes, my Lord. That is what. And there it was after the academic session, my Lord.
Ah,
Till the next academic session or
till the next academic session.
Yes, Lord.
That's why I was wondering. Can you rely on the same rules?
The so far as the first part is concerned, my Lord. And I rely on the page 74, bottom 5 line, my Lord.
Is judgment been considered anywhere?
Yes, my Lord.
Paragraph 12.
There is one more judgment.
Has it been referred to in any
Yes,
in the
Lordship.
context of Article 226?
Page 86, Your Lordship will see another Supreme Court judgment, 1977 4 SEC. as page 86, my lord, and the consideration, my lord, is at page 89.
What is the reference? Second judgment, 77-4.
Yes, page 86, my lord. And
Yes.
And second submission, my lord, is that
So
respondent.
therefore, these are the two judgments that you cite.
Yes, Your Lordship.
That you can issue executive directions.
Yes, Your Lordship.
Then the second part.
The second part is, my lord, that the respondent has not questioned the authority of the state to regulate their conduct. They regulate the power to frame rules 6 and 7 are not in question, my lord. What is in question before your lordship is the amendment. So if the amendment is struck down, my lord, then rule 6 and 7 again will regulate their conduct, my lord. So then what is being questioned, not the power of the state to make the rules, my lord. Question is that those amendments are
Not the substance of the amendment.
and they are questioning the amendment, saying that it is arbitrary.
It's the substance of the amendment which is
This is being
being questioned.
questioned, my lord.
So revert to the old position.
So therefore, what my submission for your lordship's kind consideration is, my lord, that if I have the authority to make the rules, rule 7 and 6, and I have the authority to amend the same, my lord.
And authority to amend it any which way you want.
There your lordship is testing whether it is having some nexus with the object it seeks to achieve or not, or whether some substance in the policy is there or not, whether it is meeting the test of constitutional norms in Article 14 or
Yes.
not, your lordship. In this regard, my lord, my submission is that what we are doing as of now is that we are taking away the political activities from the colleges, my lord, because teachers participating in the political organizations.
We are not even going into that part. You have in your original rule 6, you have legislature, panchayat, any form of public election.
Yes, Lord.
And you also have political organization.
Yes, Lord.
Now, office of political organization.
Yes,
now, if that is not in question,
Yes, Lord.
that is not in question before
Yes,
us, we don't have to go into that.
Yes, Lord. So, the amendment proposed to do, my lord, why? Because I am testing whether this policy is good, bad, or ugly, or whether it meets the constitutional norms or not. If it doesn't, then it has to go. My submission is, my lord, that there are certain objects behind this policy, my lord. Object may not be very reasonable, may not be very sound, but if it has some object and some basis, my lord.
Anything else?
My lord, this is the second submission, my lord. So and this similar policy, my lord, the lordship has seen Kerala judgment, which is pending in Supreme Court, my lord.
Where?
Yes, lordship. This is part of the compilation, my lord. It is in the spiral one, my lord.
Whatever you want to include, just to us now.
Yes, sir. I will do that.
I'll do.
that.
Whatever is done previously, we've ruled out.
Yes, Your Lordship. Your Lordship, kindly see page 121 of the compilation.
Just a second. So over here, you've cited from the pink one, you've cited Ajit Sharma.
Yes, Your Lordship.
And you've cited
E. Fernandez.
Cyril Fernandez.
Yes, Your Lordship. Serial number 6 and serial number 4.
And over here, you're citing which one? Page?
At page 121, my lord.
Page 121.
With the caveat that the matter is pending. And
page 121.
yes, my lord.
Let's see. Of this one.
The spiral one.
Of the pink one.
A pink one, my lord. And the paragraph 1, my lord,
Yes.
there was a PIL.
Are not entitled to contest in legislative bodies.
Yes, sir.
So this is the opposite side.
Yes, opposite. The PIL came to be filed, which the rules permitted them to contest the election, my lord.
And then what is the conclusion?
Yeah, and conclusion is at page, my lord, paragraph 120,
Just a second.
160,
Kerala case
169, my lord, and page will be,
2021. This has not yet been reported, Mr. Advocate.
yes, lordship, we tried to find out from the SEC also, my lord, and my colleague has tried his best to get this judgment, my lord, from the reported, but we got the SSC online. And the paragraph, relevant paragraph is 169, my lord. Which is
At page
which is at page
204. Oh, 220.
Yes, Lord. 169 at 226, my lord.
Oh, so this is on the Office of Profit.
Office of Profit, my lord, and also, my lord, if your lordship will see the other paragraphs at 50, the provisions are quoted at paragraph 58, my lord.
Office of Profit.
Yes, your lordship, and 58 onwards and paragraph 88, my lord.
Paragraph 88.
Yes, lordship.
Page
Page 149.
14.
9, my lord.
$58. 88.
Yes, lordship.
A combined reading the teacher appointed.
So they are discharging the public functions, my lord, which your lordship will see at page.
So it's Office of Profit only.
Yes, your lordship, and then they are doing certain duties which are meant for the government.
Yes, the government is supposed to do it, they are doing
They
it.
are doing it, my lord, and page 170 also, my lord. Paragraph 120.
Paragraph 170.
No, paragraph 120, my lord, at page 170.
120 at page 170.
Yes, my lord.
How can people write so big?
It's lengthy judgment, my lord. I am relying on these observations in para 120, my lord, to justify my policy. Yes. So, your lordship, though the judgment is on the Office of Profit, my lord, but the policy has.
There's nothing in this. This is just
Particularly paragraph 120, my lord, and last 4 line of paragraph. To put it differently, only if the teachers dedicate themselves to their profession.
not even part of any obiter or anything. This is an
Yes, your
observation.
lordship.
Passing observation.
So this was on the issue of policy, my lord. Now, the third aspect is, my lord, that so far as the issue of Office of Profit is concerned, my lord,
Office
190.
of Profit we are not asking you to.
Then,
Office of Profit is not an issue over here.
yes,
You, by your old provision,
Yes, sir.
Office of Profit was taken care of.
yes, lordship. That then your lordship will see now the law after the judgment of Justice K. M. Joseph in Anu Banwal, because before that in Rajbala, your lordship, the Justice Chilameswar held that it is a statutory and constitutional right. That has been diluted by Anu Banwal, my lord. So few paragraphs of Anu Banwal.
Not really diluted.
Let me.
It noticed that Kuldeep Nair.
Kuldeep, yes.
It noticed Kuldeep Nair, but
Yes.
not really.
Your lordship, kindly see few paragraphs of in the second compilation. Paragraph at page 114, my lord. Paragraph 130.
Just a second.
Citation is 2023 6 SCC 161, my lord.
Dilutes. Paragraph.
Paragraph 130 at page 114, my lord. The discussions
Just a second. Yes.
Is the right to vote a statutory or constitutional right, my lord? And the right to vote is not a civil right, my lord. Then various references of the judgments on this issue have been dealt, paragraph 130 onwards, my lord.
Yes.
And my lord, kindly see paragraph page 127. Which is part of paragraph 170, my lord. I will place 170, my lord, at page 126, my lord.
Yes.
We may at this juncture notice one feature
Carry on.
we may at this juncture notice one feature. Article 326 undoubtedly provides for adult suffrage. It declares that if a person is a citizen and is above 18 years of age and he is not disqualified as provided in Article 326 by or under any law, then such person shall be entitled to have his name entered into the electoral roll. It does not expressly say that he shall have the right to cast his vote. I am placing reliance on this line. Right to cast the vote as such is expressly conferred under section 62(1), undoubtedly on a person whose name is entered into the electoral roll. We have already noticed that interplay of section 62(1) and section 62 subsection 2 equally may notice that even if a person is included in the electoral roll, if he is in confinement in prison, it would not entitle him, or rather it would disentitle him to cast his vote. In other words, while ordinarily the right to vote inevitably follows from the inclusion of a person in the electoral roll, right to vote may be denied in terms of law, as we have noticed. The mere inclusion of person's name then may not all after. So
how
point
is it?
I was trying to make, my lord, is that under Article 326 or even under Article 171, my lord, there is no vested right in the respondent to contest election or to cast. There is no constitutional right. What I mean to say, my lord, there is no constitutional
Where
right.
does it say so?
So the lordship will see 181, my lord, for that. 180 onwards. $180, my lord. And 180 is the principle which is stated, my lord, and 182. And more clearly, my lord, on this issue, after dealing with Anshul, 185, my lord. we had noticed that we cannot 185 at page 130.
Only about Kuldeep Nair.
Yes, sir. So the Kuldeep Nair says that hold that there is no constitutional right, my lord.
Kuldeep Nair is 2006.
Yes, sir, lordship.
Now, did Chalameshwar notice Kuldeep Nair?
Yes, your lordship. And there in Rajbala also, my lord, if your lordship will see, because whole discussion started in the context of Rajbala, my lord. And then if your lordship would notice, because Rajbala was noticed by Justice Joseph here, my lord, and that discussion starts from 131, which culminated in the discussion on Rajbala, my lord, which is starting from.
Did Rajbala refer to Kuldeep Nair?
No, Rajbala is a subsequent judgment, my lord. Kuldeep Nair. Sorry.
Rajbala did not refer to Kuldeep Nair.
I'll just check, my lord, and
Rajbala is Justice Chalameshwar's judgment.
Justice Chalmeshwar judgment, my lord, which has been extensively dealt here in this paragraph, my lord,
That
and
will, no, but it gives no opinion on that.
paragraph 145, if you
Where is Rajbala? Is it part of
Rajbala here is dealt in paragraph.
Rajbala, is it part of any compilation here?
Here, yes, your lordship. Rajbala is in serial number 3 of the spiral.
19268.
Rajbala is 2016 to SCC 445.
Is Kuldeep Nair quoted in that one? Anup.
Anup Banwal, yes, your lordship.
Where is it?
Your lordship will find that quotation at page 117.
117.
Sorry, 11. Is there, my lord, at page paragraph 145. 119. In Kuldeep Nair versus Union of India, the question which actually fell for consideration was the validity of certain amendment which came into the force on 28th August 2003. By the amendment, the requirement of domicile in the state concerned for being elected to the Council of State was deleted. The Constitutional Bench in the course of judgment referred to PUCL and the court observed the follows. The argument of the petitioner is that majority view in PUCL therefore was right to vote is a constitutional right. Besides, it is also a facet of fundamental right under Article 19(1) of the Constitution. 362. We do not agree with the above submission. It is clear that a fine distinction was drawn between the right to vote and the freedom of voting as a species of freedom of expression, while reiterating the view of Jyoti Basu versus Devi Gosal that a right to elect, fundamental though it is to the democracy, is neither a fundamental right nor a common law right, but pure and simple statutory right. Even otherwise, there is no basis to contend that the right to vote and elect representative of the state in the Council of State is a constitutional right. Article 80.
Just a second. Even otherwise, there is no vote.
Para 173.
And distinction was drawn between right to vote and the freedom of voting as a species of freedom. Yes. The right to vote is a constitutional right. Besides that, it is a facet of fundamental right. Neither a fundamental right nor a common law right. Does not say not a constitutional right.
If you also will see 363 at page
That
120.
is the last one.
There is nothing in the
In the
constitution.
in the context of voting,
Yes, my lord.
even other they know that the right to vote in of the state of council is a constitutional right. Constitution is also a statutory right.
Yes, my lord. Grand norms.
Yes.
And Rajbala, my lord, we have checked, it did not refer to Kuldeep Nair, my lord.
Rajbala did not refer to it.
And Rajbala has been referred in Anup Banwal at paragraph 173, my lord.
Yes, Rajbala is copiously referred.
Yes. And then after dealing with Rajbala, my lord, the conclusion which I
We do not have to say anything. They leave it open.
Yes.
They don't say anything.
So what they say that this is neither constitutional right nor fundamental right. That is what my submission, my lord, is based on the reading of these paragraphs.
Need not be. Need not be. One need not make it constitutional fundamental.
Yes.
The question is whether you have authority to disqualify a person from participating in a legislative election. You do not have that authority, whether that's constitutional right or, ethereal right, we are not concerned. You do not have the authority to disqualify. That law amounts to disqualification and therefore you cannot.
One submission, my lord, one submission. The person is qualified to contest election or even participate in the political activities, my lord. What we do is that as this disqualification is there till the time you are part of the government aided college or government schools, my lord, or government college, my lord. So my disqualification is linked because he is eligible to contest election, he is eligible to vote.
Yes, that is a possible argument.
Yeah.
3 is he is free to leave.
Yes, my lord. So these are the 3 basic submissions which I have, my lord, to justify my policy, my lord. And your lordship is not going into the office because that issue does not arise also. I completely bow down.
Not a relevant
Yes,
issue.
yes, I bow down. That is all I have to say.
Tomorrow, we are sitting at 2 o'clock tomorrow.
Yes, lordship.
Then the entire thing come immediately. Yes, ma'am. Tomorrow, do you have any other matter over here? No. There's one criminal matter which is
One criminal matter is there.
criminal matter which is there.
Thereafter, your lordship.